And here we are today spending time doing that.
Mr. Chair.
Lewis Wall.
Oh, kia ora, Mr. Chair. Thank you very much for the opportunity to contribute in the committee stages of the Lawyers and Conveyancers Amendment Bill. This is a constitutional issue, and I actually do want to reiterate what my colleague Charles Chauvel said earlier in terms of this debate, because when you look at the history that started for us in 2002, yes, when we were in government, but there was a decision by Cabinet at that point in time to not only rename Queen's Counsel, but also to look at the eligibility of that very privileged and special role within our society. So for us, it was about creating the opportunity for all litigators, not just barristers sole, to have the opportunity to represent, which is the highest office, I believe, for the profession, the legal profession. And why did we do that? I think we did that actually as a deliberate attempt to try and carve out for ourselves as an independent country in a world where we have to recognise, and we will always recognise, that we were colonised by the British. We are part of the Commonwealth. But it was actually starting to forge some of our own national identity. And so within the framework of that debate and discussion, we decided that this was an area that actually we needed to reform. And so we did create the title of Senior Counsel, and we did change it from Queen's Counsel, and I think we should remember that. And so when I looked back at some of the debates, for example, that occurred in 2005, when the Lawyers and Conveyancers Act came into force, it was very interesting to note that the Law Society at that point in time actually agreed with the change. They agreed with the fact that we should be enabling all of the people within the legal profession to have the opportunity. And so the two primary drivers when we drove the change were about renaming it, but it was about the eligibility. And it was a move towards New Zealand's independence, as has been spoken about previously. So we did follow the UK, we followed Australia, and it's interesting when we look at other Commonwealth countries. For example, we have senior advocates in India, we have senior consultants in South Africa, we have President's Counsel in Sri Lanka. So what we started to undertake was something that a lot of other Commonwealth countries had started to undertake, which was actually to look at what this role represented, or what this role was empowered to do within the context of New Zealand being an independent sovereign nation. And I guess within modern democratic societies, and in a society such as ours, those are some of the challenges that we will face in the future. And we do have to recognise in this discussion that we do have a constitutional reform process underway. And so when we look at the retrospect or the retrograde of this particular piece of legislation, you do have to wonder where the motivation came from to put this piece of legislation through the House. And it seems that it was initiated by the Attorney General, Honourable Christopher Finlayson, in June of 2009. And so there was a commitment by the government to do that. But I'm not really sure why they would do that within the context of us as a country having these big discussions about the constitution of our country, the place of the Treaty of Waitangi, for example. What sort of a state do we want to create for our children of the future? So it does seem a little bit at odds that we would be discussing a bill such as that within the context of that discussion. And I was in the House when the Oaths and Declarations Bill was debated last week, and it seemed that was the primary rationale for National not supporting the Honourable Te Urero Flavel's bill. And that was because we were in the middle of a constitutional review, and so they decided we should wait for that constitutional review to take place to then allow, for example, us as members of Parliament to decide when we swear an oath to also swear to uphold the principles of te tiriti o waitangi. So that was a really interesting, principle to make a decision on, and it seems that that principle is completely transferable within the context of our discussions around this bill. And so my contribution really was just to highlight that point. Thank you, Mr. Chair.
Charles Chevelle.
Thank you, Mr. Chairman. Mr. Chairman, it's been interesting to